All right, it looks like people are still coming on the phone. We're going to get started with opening remarks. As more people will join this call as we get going. I want to welcome everyone today. My name is Lara Friedman. I am the president of the Foundation for Middle East Peace. I am very pleased to welcome you to our webinar today looking at, and this is the catchiest title in the history of webinars, Coronavirus-related cases and Israel's Supreme Court, disclosing structural failures and inequities in Israeli policies. And I want to apologize to the world for that terrible, terrible webinar title. That's on me. To shed light on what is actually a very interesting topic and an important topic, we have with us today 3 experts working in the trenches. So first we have Hassan Jabareen. Hassan is the founder as well as the general director and legal director of Adalah, the Legal Center for Arab Minority Rights in Israel. For nearly a quarter of a century, Hassan has been litigating landmark constitutional law cases before Israel's Supreme Court concerning Palestinians living on both sides of the Green Lines, among other things. Second, we have Jessica Montell. Jessica is the executive director of HaMoked, the Center for Defense of the Individuals. She has been a leading figure in Israeli civil society for 2 decades. A lot of us know her for years from B'Tselem. And third, we have Sfard, Michael, I should say. Michael is one of Israel's leading human rights lawyers, having argued countless cases before Israel's Supreme Court. And anyone who has an eagle eye will actually see behind me his book on my bookshelf there, A Wall in the Gate. So our webinar today will take the form of a discussion between the panelists and myself. This is our normal format that we're using now. People seem to like it. I like it. In addition to my own questions, audience questions can be submitted via the Q&A feature at the bottom of your Zoom window. Feel free to submit those questions at any time throughout the panel. I'll be keeping an eye on the Q&A box and will do my best to factor in your questions to the discussion. And of course, note that this is being recorded and will be posted online immediately after it ends. Finally, if you have any technical problems during the webinar, let us know using the chat function, which my colleague will be watching. Please do not use the chat function for questions because I actually won't be looking at it carefully and I may miss them. So with that, we are going to get started. And I want to start off with Hassan. Hassan, can you talk to us briefly? And we're going to ask people to have, brief interventions so we can have several rounds of questions. Can you talk to us briefly about Adalah and the role Adalah plays vis-a-vis Israel's justice system?
As you mentioned, Adalah is a human rights organization. Our main project is litigation before Israeli Supreme Court, and beside that, also we do international advocacy before UN bodies and EU bodies and others, and create and build and partner of international coalitions. And now the vision of the organization locally here within the Israel legal system is based on state for all of its citizens, equal rights for all, and in the occupation. So by those definitions, you can imagine the difficulties that we face and the challenge that we put. Difficulties because the cases should be difficult cases when your vision is state for all of its citizens, and the state and the legal system define itself based on the constitutional values of Jewish and democratic state. So this brought difficulties, obstacles for us, but at the same time, we brought challenges to the legal system in many different cases. Many of our leading cases are, in fact, defending equal rights for Palestinian citizens of Israel, including unrecognized villages in the south, in Naqab, and also we have cases that lately focus more on Gaza Strip, challenging aspects of the siege. I can say that our cases in the last 20 years were mostly, we can say, the leading cases constitutionally before Israel Supreme Court, because they are coming and fall within the core of the constitutional identity of the state itself.
Wonderful. And I want to just point out that my colleague Kristen has put into the chat box the link to Adalah's website, and she'll be putting in more links, so keep an eye on that. for the details with the other participants, their organizations, their Twitter handles, that sort of thing. So turning now to Jessica, same question. Give us an introduction. HaMoked, its work in the Israeli courts, its philosophy, that sort of thing.
Yes, thanks for having me. HaMoked is an Israeli human rights organization founded 31 years ago. And the bulk of HaMoked's work is individual assistance to Palestinians, and through individual assistance, also working to make strategic change. So we're assisting about 5,000 Palestinians a year through paralegal assistance, and when that proves unsuccessful, through litigation. And HaMoked is probably filing the most cases in Israeli courts of any body in Israel, human rights organizations and other groups as well, both to the High Court, but increasingly with the changes that have been made to the legal system, now much more frequently to lower courts as well. And very often you're talking about issues of freedom of movement, of residency rights, petitions against punitive home demolitions. I said in the previous discussion that we had, occupation for most Palestinians is a permit bureaucracy. That's the main daily manifestation for Palestinians. The fact that you need a permit to go anywhere, do anything, even live in your house. And HaMoked is challenging many of those, both at the individual level and through individual litigation and strategic litigation, also trying to make more structural change.
Fantastic. And I want you to put a pin in the comment you made about the changing structure, the fact that some of the cases are going to lower courts now instead of the Supreme Court. When we get back to it later in a conversation more about annexation, I want you to expand on that a little bit. Switching to Michael. So Adalah, HaMoked are part of an ecosystem that exists in Israel of NGOs working to challenge Israel's policies using the justice system for years. You've been working alongside and with many of these groups for years. Can you talk briefly about this as an overall approach, what it looks like, what it's accomplished, and why it came about?
Thank you very much for convening this group. I haven't seen my colleagues for a while because of the lockdown, so it's a good opportunity to see them. Israeli civil society and its attempt to pursue social change through the courts, among other methods, is part of the tradition of cause lawyering, which you in America have since the civil rights movement, and even before, during the abolition, the fight for abolition of slavery, etc. And the premise of using the judiciary for social change, the naive but nice story that cause lawyers tell themselves everywhere, is that of all three arms of government, the judiciary is the one, since it's professional and independent in those countries that it is, and since it's not subject to ratings and re-election and things of that sort in the places where judges are appointed for life, they are less susceptible to populism and to the trends of the day. And they are more likely than the executive or the legislator to provide some protection to minorities and to weakened communities. That's what is at the basis of the choice that is made by all lawyers, cause lawyers, human rights lawyers around the world. And in Israel, it's the same. I would just add that we have one more feature that is striking and leads many of the waves of litigations in the Israeli High Court of Justice, and that is the fact that we have an ongoing, more than 5 decade ongoing occupation. And the residents of the occupied Palestinian territories are not just weakened communities or minorities. These are people who have no representation in any other arm of government. They don't have a representation in the judiciary as well, but they are represented they can be represented before the Supreme Court. And so their spectrum of options on how to fight for their rights or against the abuse of their rights is very limited. And so the court is one of those options. What is the record of that court? We'll maybe talk about that later.
Terrific. And thank you all. Those were very succinct answers. That's fantastic. You're winning compared to all of the panels I've ever done. Going back to Jessica, in the context of the COVID-19 crisis, which is the framing of this call, HaMoked has brought a number of cases before the Supreme Court. Can you talk about those specific cases a little bit?
Yes. So coming out of our work throughout the year, then we are receiving calls from Palestinians with all of the different difficulties that Palestinians are facing. And I think they can be categorized into two sets of categories. One is neglect, that Palestinians are not on the radar when they're thinking about responding to this crisis. And then you need advocates to say, hey, when you're planning and thinking about responding to people's needs, you also need to respond to the needs of Palestinians. And the second set of categories is an exploitation, taking advantage of the situation to be pursuing an agenda that really has nothing to do with fighting the coronavirus. So the first set of issues that we are very concerned about are prisoners. And around the world that that's a very vulnerable population. You have inherently overcrowding. It's very difficult for people to be maintaining all of the regulations, cleanliness, hygiene, social distancing in prisons. And one of the first outcomes of the corona crisis was to shut off visits from families and also from lawyers. So we've petitioned the High Court, and Adalah has a corresponding petition. Our petition says, so long as you don't have families that are visiting, what that means now is Palestinian prisoners are completely isolated from the outside world. At least they have to have regular phone calls. And the way the system works in the prisons, prisoners are divided into two categories. You have criminal prisoners, you have security prisoners. The vast majority of the criminal prisoners are Israeli citizens. Now they have regular phone calls. So even when there's no visits, they still have contact with the outside world. Most of the Palestinian prisoners are defined as security prisoners. And now they are completely isolated. I mean, no lawyers visits, no families, no way to contact. The families outside also are in a panic. Who knows who has tested positive, who's been in contact with people who have been sick. So that's one petition which has had partial success in that already minors, children who are in detention are now able to make bi-weekly phone calls with their families. We're still pushing for adults as well. And then all of the issues relating to freedom of movement of Palestinians, particularly around East Jerusalem, that we have yet to file petitions to the High Court, but are in sort of pre-petition stage around the threats to cut off areas of East Jerusalem from the rest of the city, imposing checkpoints that lock down a village so that they can no longer move, cutting off access for farmers to land behind the separation barrier. Those haven't reached the court yet. But interestingly, you have issues that we petitioned the court about prior that are still going through the courts. I mean, punitive home demolitions, although it's crazy to think, and even one of the judges said to the military, really, you're going to demolish a home in the middle of the coronavirus crisis, but that HaMoked's petition against a punitive home demolition is also under discussion now at the High Court.
Fantastic. Turning to Hassan, I know Adalah has, I think, 6 cases now before the Supreme Court, at least 6 cases, based on the brief that I was reading just before we got on this call. Can you run us through the issues that you guys are litigating right now, and what that environment looks like for you?
Yeah, we have now 8 Supreme Court, 8 cases before the Supreme Court. And we are submitting also Sunday another case. And I can say that there are 2 kinds of cases. Some of the cases are dealing with specific Palestinian areas that they don't have access to health system that relate to corona, and others universal that can deal not just with Palestinian citizens, that they can refer to all the citizens. We found in this crisis that what we know all the time, and what was problem is still a problem, that you don't have infrastructure in health issues. And this is why we have, first of all, to deal with this problem. So we filed cases on behalf of the people who live in unrecognized villages. In those villages, they don't belong to any local council. Thus, there is no health services and there is no transportation. And of course, in the time of the siege, they cannot go to any other place to travel. So we have cases referred to them in two matters: health, to have testing and places for isolation, and also in education, since the education system decided that to have remote education, and there you don't have electric infrastructure for that, so this has become a problem. Another area that we found that similar to the unrecognized villages are the Palestinian areas, that they don't belong to the Palestinian Authority, but they are under Jerusalem jurisdiction, but they are discriminated historically. So they are like the sandwich areas, that they are not under PA, and Israel doesn't want to see them as a people under its authority, but want to see the land of them under its authority. So we submitted a petition on behalf of the residents of Sfard refugee camps, that when we submitted the petition, there was no any mechanism of testing in this refugee camp. Also now we are going to target areas in Jerusalem neighborhood that also that they face similar problem of Sfard. Other area that we are still worrying about is the prisoners area. As Jessica mentioned, that we filed petition to have access to lawyers, to the prisoners, criminal prisoners. And now we are going also to submit petition about the conditions in the cell of the security prisoners, because there is no any social distance in those cells, so the people there, the prisoners under risk situation. Now the universal cases that we have with other organization, ACRI and other private lawyer, challenge the power of giving the GSS, the Shabak, to use surveillance in order to provide information to the health ministry about people who came with contact with sick people. And of course, this Israel used this mechanism, and the only state in the world that use publicly secret services of its GSS, and to violate the right of privacy of all of the citizens. And the Supreme Court accepted our argument that the struggle against Corona is civilian struggle and has nothing to do with the goal of the GSS, which should be limited to security matters in the strict meaning of security. Now we have also case before the court that the court decided that will be with wide panel, and hopefully that the court will hear it next week. We are challenging the power of the government to issue emergency regulations. We argue that there is no power for Israeli government to issue those regulations. Those regulations should be regulated by the parliament. The parliament should provide the power and should put through laws the limit of the power of the government to issue such regulations, because the regulations that Israel government issued daily with no transparency, without public discussion, and even there is no law authorize it to do so, the law says, first of all, you have to go to the Knesset, and the Knesset must declare that the situation is emergency situation regarding Corona, and to decide what kind of power the government will have. This, like I can say, the most principled case that challenge the emergency power of the government.
Terrific, and I want to get back to that in another round of questioning. Michael, I want you to, again, take a step back. The cases that Jessica and Hassan are working on right now, they talked about, obviously do not arise out of nothing when COVID happened. They both talked about sort of the universal versus the specific. Can you talk about, and this goes to the framing of this whole conversation, can you talk about what these cases, the issues that they raised, what this discloses about the underlying problems in Israeli society, structural problems, and how or whether these have been previously challenged before the Supreme Court?
Well, I'll try to summarize a thesis that could furnish a PhD, but I'm not planning on any PhD, so I'm happy to disclose it. In the beginning of the 1990s, an Israeli scholar published a book that became quite famous, and following it, the scholar became quite famous, arguing that in the 80s and 90s, the Israeli Supreme Court has changed. The generational change of the Israeli Supreme Court has brought with it what he called the decline of formalism and the rise of value-based adjudication. And I want to say, looking at all of this from a little step back, as Lara, as you said, that we're witnessing a process in the opposite direction. We're seeing that we have, in the last decade, again, a generational change in the Israeli Supreme Court, and we're seeing a trend, a process of the rise back of formalism and the decline of value-based adjudication in a country that has a very powerful executive, very limited parliament, because it is always dominated by the government, by the executive, because of the system of government that we have, where it's a party-based judiciary, and the parties are in a coalition or an opposition, but they usually are voting in the coalition lines. And so we have a very, very powerful executive, and in this kind of a system, the role of the judiciary is especially acute. And in the cases that we've heard about that are litigated so marvelously in these very difficult days by Adalah and HaMoked and others, what we see is exactly the same kind of tensions that we see every day, not only when there is a health crisis. We're seeing the attempt of the government to get more powers, to drive us into an authoritarian regime, and we're seeing the Israeli parliament becoming weaker and weaker. And what we're seeing with the courts, and I'll try to be short, is that while in the past we would expect cases like the ones we heard about now being ruled with a very deep analysis of the merits of the issues, of the tensions between different interests and rights and fundamental rights, etc. What we're seeing now is that the court is running away from these questions to the more procedural issues. The decision, the very important ruling that Hassan litigated on the Shabak powers was eventually decided on the basis that such powers, if granted, should be granted by the legislator, not by the government. So what we're seeing is that while there is still a pocket of the old guard of the Israeli court that is trying to revive the days of Barak and Shamgar, we are seeing more and more the court, also because of the pressure that is mounted on it, cornered into a position where the court is only the only thing that it's trying to do is to protect the rules of the game rather than the merits of it. This is how we can explain the very courageous decision to coerce the Speaker of the House, of the Knesset, to allow the majority of Knesset members to have their a vote on a new speaker. This is how I understand also the decision in the digital data surveillance case. The primary legislation, the Knesset should be the one deciding on such matters, not the government. And so we are to expect, if this trend continues, we are to expect more and more litigation that is based and decision-making that is based on process and procedure rather than what we were used to deal with. What is exactly the right to privacy and when can it be trumped? And is it indeed something that can be subject to such immense violation as the government has done with the Shabak powers? So this is a major shift which will us as human rights lawyers and human rights activists, we will have to reevaluate what is and how we use the courts if this is where it heads to.
So I want to stick with you for a second, Michael, and follow up. And what you describe, I think we've seen it in other places as well, including the U.S. to some extent. It's even more significant in a country that doesn't have a constitution. So it's if the High Court has played that role for years, in a sense, to sort of interpreting the rights and values. Following up on what you're saying, so all of us who watch Israeli politics know the judiciary has been under siege in Israel in recent years. Can you talk to us more about that, about the hatred of the Israeli right for its rulings, the attempts to underline and sidelining it, make it subordinate to politicians or to the Knesset, and outright efforts just to remove cases from the docket? What does that look like right now? If you're a Supreme Court justice trying to figure out what to rule on and how to rule in that environment.
I just want to fine-tune your assertion that Israel does not have a constitution. In very rough terms, it's true, but we do have a partial constitution. We have basic laws, and one of the weaknesses, one of the problems is that every legislator, every Knesset is also a constitutional author, and may add patches to this partial constitution, which is very problematic. Nations usually write their constitutions in one chunk, in one go, in a very important historical moment. And that's not what is happening with Israel, and it's another problem. As for your question, look, Israel has, just like any other, I think, country, state, and any other civil community, has different political wings, which hold different ideological convictions. It has many competing interests within our life here, and that is regular. But there is, I think, one reactor that generates the vast, huge amount of energy and power that eventually is the driving force behind the major political action in our country, and that is the Israeli-Palestinian conflict. And everything else is there, but the Israeli-Palestinian conflict, at the end of the day, this is what governs politics in Israel. And because of that, and because of the rightist vision in that sphere, the rightist vision demands a more authoritarian regime, less weight to civil rights and definitely to the idea of equality. It demands some kind of readiness to absorb an apartheidist reality without entering to the question, the difficult question when apartheid will begin or has begun. but it has to have some kind of steel stomach to allow this kind of reality. All these things are things that the value-based system of judiciary, which sees itself as liberal. And again, I'm not going into the question of whether they were really liberals or are they liberals, but they were thinking of themselves, the Israeli judges of the 80s and 90s, as advancers of liberal democracy with a Bill of Rights. And so this kind of a judiciary slows down a process of bringing the rightist vision, and it also mitigates some of the powers of the judiciary, of the executive and the legislature when it comes to these kind of questions. It does those two things, but it also does another thing. It maintains the political space for the dissenters of this vision to operate. And we've seen, and that is maybe even more than the other two, because the court would not be the one that would stop annexation. The court is not the one that stopped in the past. It doesn't stop house demolitions during Corona. It didn't stop many things. It actually koshered a lot of things. But it maintained, again, some space for the opponents of these things to operate. And these opponents have their power. We're not a majority in Israel today, but we have some weight, and we have weight outside Israel, in Jewish communities, in the diplomatic world, and in the media, and in Israel. And this is something that the rightist vision cannot tolerate. And as I see that, my analysis is that everything that eventually, at the end of the day, yes, there is Netanyahu and his corruption charges, which piles on top of this. But eventually, the reason that is behind the rightist drive to curb the Israeli judiciary, to annihilate its independence, is driven by the desire to create a Jewish supremacy government between the Jordan River and the sea.
So that's a great point for my next question for Hassan. So taking that framing into account, the challenges of the High Court and its authority, the underlying, and this goes back to, again, structural challenges in Israeli politics. What are your predictions or hopes regarding the outcome of the cases that you are litigating now? I mean, how does the overarching politicization of the judiciary affect your work and affect your strategies now and going forward?
We have a result of those cases, and those results can speak about the nature of Israel's legal system. As I mentioned in the beginning, that Israel defined itself as a Jewish state. That means that equal rights is not really equal between all of its citizens. There is a group that they have full equal rights and the other less rights, second-class citizen. So the meaning of equality has different aspects before Israeli Supreme Court in practice. In rhetoric, they maybe will say that equal rights for all, but in practice, in each case and case, they will apply different doctrine, different principles. So, as I mentioned, that our cases, two kinds of cases. One refers to Palestinians in different localities, and one universal. Those cases that they have universal aspect, the Supreme Court hear the case, some of them twice, and we succeeded fully. Not about the GSS only, and also about women's rights, that one of the regulations allow the businesses to send women, pregnant women, to unpaid vacation. This affects Palestinian women and Jewish women. This is why our success was fully. Why fully? Because it applies to all citizens. GSS was fully because the judges themselves will be, and their son and their daughter, under surveillance. This is why we succeeded. However, the other cases, I cannot speak about success. We got gista, not equal rights. Gista. So, for example, it was enough after we submitted the case for the unrecognized villages that they don't have any access to health, that the state in its response promised that they will send some clinics, few clinics to those areas that they need more than some clinics. It was enough for the court to dismiss the case without hearing us, to say that this response is satisfy us, and we hope that they will provide those services. Shafat camp 120,000 people. We submitted the petition. The state responds and say we are going to open 1 to 2 clinics, when Shafat need 10 clinics. It was enough for the court to dismiss the case without hearing us, without inviting us, because this gista for the Palestinian is enough. So when you have this constitutional aspect about this state belong to one people and not to all of its citizens, and you have the basic law, which called the nation state law. So of course, equal rights has different meaning. Equal rights can be satisfied by providing humanitarian access. So in those cases that we are winning for the Palestinians in different localities, we are winning that under concept of humanitarian aid, not that rights that citizens are entitled. The citizens of the unrecognized villages, they pay fully taxes to Israel legal system, but they don't have those rights because their constitutional rights are suspended. Why suspended? Because they live in places that Israel doesn't want to recognize as villages, meaning that they belong to local council or the people can build their houses there legally. Why? Because one of the notion of Israel as Jewish state, that the land should be within the hand of the state. So all the time, the struggle over the land in the south is very high political conflict. And here we see that Zionism, in this aspect, reached Corona. Like why the people in the unrecognized villages don't have equal rights? Because the Zionist perspective of the state is that this land should be the land for the state and the unrecognized villages should move and transfer to other places. So here you can reach the philosophy of the state as exclusive and discriminatory philosophy and policy that can reach in the end of the day this crisis of Corona and this time of emergency, which this time is totally different than any other emergencies that we passed. In the past, in all the world, emergency based on security matters has the aspect of distinction between friend and enemy. Corona doesn't make this distinction. Corona make the personal body, his body, her body is the enemy. And the body is colorblind. It's not the Jewish body. It's not white body. It's not Muslim body. It's not Arab body. Everybody. So we expected, because Corona pushed us to start to think that the state should be equal to all, that also our cases will be easier. Yes, they were easier in some aspect, but in places that the case come with Palestinian petitioner, he say, oh, I am Palestinian, I have been discriminated in health matters for ages. Please, help me to pass Corona. Well, you spoke as Palestinian, the court will refer to you as Palestinian. So we were surprised that between the comparison between the cases that has universal aspect and Palestinianhood, aspect how the court treat them. Still, like when you live under a discriminatory system, sometimes you are happy even for the gista itself. So really, we are happy for the gista itself, but doesn't mean that we accept it.
Right. No, that's very sobering. I do want to say for people listening, if you are unfamiliar with the concept of unrecognized villages, there's a great deal of information on this online, including on Adalah's website. I would say this is something you should look into. It is fundamental to many of the disparities and inequities that we're talking about here. Jessica, if I could ask you to address the same question, given all these pressures, and Hassan is essentially saying that the court is much harder to deal with when you're focusing on the particular that is Palestinian, the sort of things that the court has traditionally said are political, right? So they're not easy to rule on. And that's really what you do entirely. So can you talk about your experience there with the court, with gestures, and with that decision of what the prospects are on this kind of work?
Yes, the climate for the court, as Michael laid out, has grown increasingly hostile. And then you have this disconnect between the public narrative around the court and our experience of the court. So the court that is extremely hesitant to intervene, to dictate to the government what to do, more and more extremely conservative, right-wing, settler judges being appointed, and at the same time, this rhetoric that the court is this, super left-wing institution, anti-Zionist. I mean, really the most crazy rhetoric against the court. And then you think of judges in that climate ruling on our cases, which are cases that are challenging, challenging occupation, really the building blocks of occupation. So it's an extremely difficult climate, and yet the court is, I would say, the most important tool we have for making change, in spite of all those difficulties. I mean, I sometimes misquote Churchill to say the High Court is the worst human rights advocacy tool except all the other tools. So, this is the toolbox we have, right? And you think, how are we going to be promoting human rights in this situation? International advocacy is important. Outreach to the Israeli public, the press, demonstrations, all of those things are very important. And we know that all of those things are extremely limiting. So yes, the High Court and all of the courts are functioning in a very difficult climate. And still, I would say, when we look at where we have succeeded in making change, litigation, and often it's not the justices ruling. Often what happens, I mean, the tiny little example of Palestinian boys in detention who now get to call their parents, the state offers this to avoid a ruling of the High Court. So frequently the fear of a High Court ruling is more effective than actually the judges. I mean, most of the rulings of the courts are not in our favor, but it's enough that a minority of them are in our favor that we still see this as one of the most important and effective tools that we have.
So to follow up, I'm actually going to shift gears because you've already covered pretty much what I wanted to ask you next. I want to go back to this question about access to the High Court, which is a fairly technical issue, but in the past year or so, Israel has fundamentally changed the rules of the game for Palestinians in terms of their access to the High Court. Can you talk a little bit, first of all, about why Palestinian cases go to the High Court in the first place? People think here of the High Court as a court of last resort as opposed to a court of first resort. And also, if I can ask you to speculate a little bit on what happens in a case of annexation, where you have Palestinians in the West Bank brought under full Israeli law, how that may or may not change access to the court system.
So a year and a half ago, you had a new law put into place, pushed forward by then Justice Minister Ayelet Shaked, that the vast majority of scrutiny of government and military action in the occupied territories would be heard at the Jerusalem District Court and not at the High Court. And her rationale is, a land dispute between neighbors in Tel Aviv is heard in a district court And, you know, we want to blur the distinction between occupation and Israel, you know, downgrading these issues and the concern for the human rights community. You know, a lot of our arguments are resting on international law arguments. It's unrealistic to expect district court judges to really be engaging. I mean, as Michael said, it's rare now that high court justices are doing that, but certainly at the district court, you know, to be wrestling with international humanitarian law and human rights law standards. What the implications of that mean is that all of the cases around freedom of movement, around land issues, dozens and dozens of cases that in the past we would have filed to the high court go to now to the district court. And your question about Israel's Supreme Court functions both as a court of appeals, as you know, the United States system that you get to a higher court after exhausting lower courts, and also functions as a court of first instance for challenging government action. So those are the cases that go to the High Court of Justice. And what I can say, you know, just the bottom line, although we were very worried about this move to the district court, even in terms of, you know, the success rate of our cases, in fact, it is basically the same. I mean, you know, we lose many cases, but we win many cases also at the district court. But I would just say now in the coronavirus crisis, the district court is still closed. You know, there is, you could easily build the conspiracy theory that it's because Netanyahu is supposed to be tried in that court. I mean, IKEA is open and beauty salons are open, but the district court is not open in Israel yet. So those cases we cannot be pursuing at this time. And then your second, you know, huge question that you have to invite us back for a whole nother webinar on annexation. I mean, really the question is, what is being annexed? Are we talking about only Israeli settlements where you don't have Palestinians? So Palestinian land, certainly privately owned Palestinian land, would be annexed, but the people themselves would not be annexed? Or you're talking about all of Area C or all of the Jordan Valley, where then also you would have Palestinians who would become under Israeli jurisdiction. So there are a lot of questions about the details before we can analyze, but I would say, I mean, just, you know, in a very shorthand way, that East Jerusalem is probably the model. It's hard to imagine that they would give citizenship to a large number of Palestinians in the West Bank if their areas were annexed. They could use this model of, say, they're allowed to apply for citizenship the way East Jerusalemites are. The reality is they have this permanent residency status, which isn't actually, you know, very permanent. And then this, you know, hybrid situation of living in the Israeli system, but in a much more vulnerable status. But really, the devil is in the details when we talk about what is meant by annexation. And of course, it's a huge challenge for the human rights community to then think how we go about, you know, first trying to prevent annexation in the first place, but then advocating for rights. I mean, if there is this new reality, building a strategy to be maximizing Palestinian rights in that situation.
Fantastic. Shifting to Hassan, I'm looking at the questions in the Q&A box for a little bit. I want to actually ask you, looking ahead, to talk about cases that you see, and this has been raised by a couple of people in questions, cases that you see coming down the road, whether about Palestinians in East Jerusalem or some continuation of the cases challenging the underlying things that are coming up under COVID, whether it's related to the emergency regulations. As we remain in this COVID crisis period for now, but looking ahead to when we come out of it, into what is going to be a tense political period as we count down to potential annexation. Are there cases that you see coming down the pike that you want to discuss?
Yeah, the cases now, of course, the priority of the cases are focusing on health matters, testing and bringing clinics and so on, that refer to the body, to save the body, to protect the body. But the other cases that we expect that we will have will be very, very hard cases that after Corona. After Corona, we'll find that Arab towns and villages inside Israel will collapse economically. Now the unemployment among the Arab citizens is very high. Before Corona, if we take all the Bedouin towns and many of the Arab villages, they were on the scale of socioeconomic status, the lowest in the country. And usually among the Palestinians, their businesses that they have, they are small businesses, family businesses, that they give services, and during Corona, all of them were closed. And the state doesn't provide serious aid to the Arab local councils. For example, lately it was a decision of the Interior Ministry to provide aids, finance aids to all the Israeli, including the Arabs local councils. But the criteria was that what those local council lost during Corona from closing industrial businesses. Industrial businesses bring high local taxes to those municipalities. So the state want to compensate those local councils. But the Arab council, they don't have those industrial businesses. Thus, from all the budget, although the Arabs are 20%, the Arab got from all the budget is 1.7%. And the others went based on this criteria to the Jewish local councils. So we are very, very worried about the day after, because we started to see now the collapse of the families. Even I cannot speak about the collapse of the Arab economic in Israel, because there is no Arab market in Israel. But the families, the rate of unemployment among them. Now, we are sure that the health ministry will reach every person regardless to his or her ethnic identity if the person identified as a sick person. Because this person can move from place to place and affect the other. So the policy should be colorblind. But we are not sure that the preventive health policy is equal. So preventive health policy needs more infrastructure, more access to health. So we expected that in the second wave, we will have very, very high numbers of people that they enter and be identified as sick persons among the Palestinians in Israel, with collapse of their economic situation. This is why we started to think to mix our legal strategy, not only to deal with health matters, also with economic matters. So we are thinking with the Arab Local Council to file a petition to the Supreme Court next week about the gap in budget allocations between the two sectors. So we are not optimistic about the exit. We will find now, when you are during the emergency, all the time you look to the time itself as temporary, that you live this moment, but you are thinking about the becoming moment. But when we move to normality and Corona behind us, we will find that the present that we will live will be very, very difficult. But then organization like Adalah that leading a Palestinian human rights organization in Israel, should move to social and economic rights and to focus on social and economic rights after Corona. But we are not sure that we can decide this decision, because when you have right-wing government that will continue to limit civil and political rights, so also you have to deal with racism and racist laws and other. So we will have this mixed agenda. But Corona gives some optimism in that tell us, well, it doesn't matter whether you are Jewish or Arab, everyone should be treated equally. But when we dig inside, we see the racist politics is the strong politics, even in some beautiful crisis, emergency like Corona. Sometimes we say to ourselves in ironic, satire way as staff member, we will live with Corona for a long time if this is the situation that we will be treated equal. But immediately we found that politics trumped the Corona and trumps the bodies itself.
Okay, that is a lot to digest. We're all going to be watching carefully, and I encourage people to keep track of these cases on Adalah's website, also on HaMoked's website, their cases. This is really important work. I want to bring this back to Michael, and this may actually be the last question we get to. And I want to combine it with at least one of the questions we've seen in the chat box. So you have been arguing cases before the Supreme Court for more than 20 years or so. Since I've known you, we've known each other a long time. I know that your views on the value of this kind of litigation have evolved over time. In fact, you wrote an entire book about it. Jessica said earlier that the High Court is the best tool. It's the worst tool, but the best one available. All of that. Can you talk about your views on this kind of litigation, its value, what it can achieve, and what are the dangers of it actually sometimes doing more harm than good, or maybe ignoring other things or limiting the chance of, say, like the ICC moving or something like that. And I think this will wrap it up. We'll get to 12 at least with your answer.
Well, not only did I wrote a book about it, but the book is some 500 pages long, so it will be quite difficult for me to summarize it. But I'll try to make some bullet points. I think human rights lawyers and cause lawyers in general, not just human rights lawyers, but other lawyers who do work that to pursue social change, have to be humble about the role of litigation, in achieving major changes. Litigation can never be the driver on the driver's seat. It can never be the major force that drives the change. But it can be a very powerful and very significant tool that assists and enriches a movement for change. And I'm, again, of course, talking about an open society, a society where people are allowed, more or less, to say what they think and to pursue political goals. The judiciary, and again, I'm assuming that the judiciary or the judge, the court is, again, more or less independent, more or less professional, that the people who sit in courts and adjudicate cases are not forced to hand out certain rulings, and that they are expected to provide their rulings according to the law rather than to other parameters. And if that is the case, then courts do have some features that I think always can provide, I call it peripheral fruits for the movement, because what we've seen, and when I analyze 50 years of litigation on occupation-related cases, what I found was that there were several major victories. There are many small victories for specific people, and I think HaMoked is probably one of the NGOs in Israel, human rights NGOs, that has the most number of these, local victories in which a certain individual or a certain family got their right, and that is a good enough reason to continue going to courts, even if on the large scale we are losing. But when it comes to principal cases, and when what we see is that the court provides us with many things that sometimes are not the remedy we're seeking, the direct remedy. It provides us with a lot of information. A lot of the things that we know about the occupation, a lot of the things that we know about Corona and the way the government is waging its battle against that pandemic, is thanks to the duty, the obligation of the arms of government to provide a lot of information in litigations. So we get a lot of information in litigation. We save a lot of time. There are many, many good examples of how major cases that eventually were lost. Take Susia, for example. Take Khan el-Ahmar. These are cases that were litigated for years, 17 years and 11 years. And they were all a defeat at the end of the day. But the time that these litigations took, and during that time, other types of mobilization of advocacy were opening. And then when finally the state or the bad guys won, there was a whole new situation which for other reasons precluded the ability to go on with the forcible transfer of people of those two communities. So these are two examples where time was crucial. In litigation, we get a lot of those things, including media attention in general to a specific issue. So I don't see a reality where the courts become completely abandoned by human rights activists. I think the courts would always be there. We have to strategize our work in the court, not file any petition that we can think of and we can word the argument in favor of. We have to think what are also the prices that we pay. And in the past, the prices were quite high when the court enjoyed a lot of respect in many circles. And losing in court in a human rights case would mean a stamp of closure from a panel that is highly regarded by many people. I don't think this is the case today. I think today we have much less of a price to pay if we lose it in court, in that legitimization currency. But in any event, we have to think twice and three times before we go to court and see what kind of path we see. And yes, sometimes we go to court even when we think that it's very likely that we will lose, but we will gain some of these other things that will help the movement. And one last thing, the court is also, and still is, a good arena to push back on the attempts to shrink the space for activists to voice their views and to act. And this is also a very important thing because as movement lawyers, and we're not just, the NGOs and the lawyers and the other activists in these organizations, one of the things that we are obligated to pursue is to enable our friends and our comrades in the anti-occupation movement, in the equality for Israeli Palestinians, in all of these movements, to allow them the space to pursue those goals. And the court is crucial in these things.
Thank you. And that is a hugely important point and a great place to end. So we've run a little bit over time, and I wish we could go on for another hour. On behalf of the Foundation for Middle East Peace, I want to thank all of our participants, Hassan Jabareen, Jessica Montell, Michael Sfard, and thanks to everyone who joined the webinar and all the people who submitted questions. I I wish we could have gotten to more. If you want to know more about any of the issues we've been discussing here, follow our guests online, on Twitter, and check out our website, fmep.org. A recording of this webinar will be posted immediately after this call ends, and also announcements about other webinars and other information, including we have a webinar on Friday, which we'll look at Israel's domestic political circus. I found a better title for that one, with Dalia Scheinlin and Neri Zilber in conversation with Peter Beinart. That's going to be terrific. I hope you all will join us then. So thanks, everybody, and good evening to our colleagues in Israel, Palestine, and good morning, good afternoon to everyone else. Thank you very much.
Thank you.
Thank you.
Thank you.